Mason. I'm an attorney with Richard Judicial Immigration Law, and today we're going to be talking about a recent Supreme Court decision from the 2023-2024 term that deals with immigration. In this case, it's Loper Bright Enterprises versus Raimondo. By way of a little bit of background, back in the 1980s, the Supreme Court issued a decision called Chevron. And under this decision, federal courts were required to provide what they called Chevron deference to the administrative agencies where they were interpreting ambiguous provisions of federal law. So, for example, suppose Congress was to use a word in a statute but provide no definition for that word. The administrative agency may then come along and provide a definition for that word, or lay out the criteria for what constitutes a specific product or a specific process under federal law. In other cases, suppose in an immigration context, suppose that we needed to understand what constituted an aggravated felony, but it wasn't defined. The Board of Immigration Appeals may provide a definition for that particular phrase, aggravated felony, or it may hold that certain crimes fall under that particular definition or fall under that particular word or that particular category. So with that background in mind, Loper Bright reversed Chevron. This means that courts are no longer obligated to give deference to the administrative agency's interpretations. Now, this does not mean that they will do away with them entirely. There is another deference called Skidmore deference, in which the administrative agency can put forward its rationale and its reasoning for why it defines something a certain way or takes a certain position. But the courts, and depending on how good that rationale is, the court may still adopt it, but it is not obligated to provide absolute deference to the administrative agency. So what does this mean functionally? Well, there are any number of terms that USCIS, the Department of Justice, etc., have defined over the years or taken certain positions on. With the overturning of Chevron, this means that some of these decisions, some of these definitions can now be challenged in federal court without having to deal with the fact that the court will provide absolute deference to the administrative agency's interpretation or definition. For more information, please call Richard Judicial Immigration Law.